Now, there's been growing concern over how the Section 194 Committee into Suspended Public Protector Busisiwe Mkhwebane's fitness to hold office handles proceedings. Advocate Mpofu, representing Mkhwebane, recently raised concern over how the chair of the committee disrespected her legal team. There's also concern that the inquiry has not been able to protect witnesses, including recently Thuli Madonsela during her testimony. Joining us now is legal expert Pierre de Vos, who penned a piece on this. Pierre, thank you very much for your time this afternoon. You start off with the contention that Madonsela and other witnesses deserve better treatment. What did you observe that led you to this conclusion?
Well, normally, you see, this process is complicated because it is an inquisitorial process. So it's not supposed to work like a criminal trial. So it needs to be less conflicting. But even in a criminal trial, there are some limits about how witnesses are treated. The purpose should be always in cross-examination to test the evidence of the person testifying and their credibility, of course, going with that. It should not be to score political points, to insult people, to make, cross-examine them on factual assertions that are actually not true, or on the basis of legal principles that are not applied. All of these things happen before the committee, and that sort of wastes time, because then the cross-examination is also not effective. It doesn't do what it needs to do, and witnesses are subjected to the kind of questioning that goes far beyond what is needed to test the veracity of what they are actually saying. And that is not good for the process. And of course, as I said, it wastes a lot of time.
You note that Advocate Mpofu crossed the line playing the woman and not the ball. How so?
Well, apart from the really, I thought that was scandalous, stating at the hearing all the insults that Advocate Madonsela had to endure. What struck me is the 3 hours at the beginning of the testimony on Monday, when he pursued a cross-examination based on a claim that the law requires any affidavit to be signed in some way by the person making it and the person taking the oath. That's not the law. So that creates the impression that Advocate Madonsela did something wrong, illegal, even criminal, when that is completely false. So that's very unfair to a witness, because of course people who don't know the law might not actually realize that this whole line of reasoning that might look like it's discrediting the witness is really discrediting the legal representative doing the cross-examination.
And therein enters the chairperson of the committee, this understanding of the law. Does it appear to you, at least, that it was there? Because even with the intervention, what was it based on? What did you observe?
So the problem is really something that is a little bit inherent in the process, because the process was presumed when the rules were made to be, as I said, an informal inquisitorial process. Now that legal representatives are involved, there has to be some rules about what the chairperson can and cannot do. Normally in a court of law, criminal courts say, the judge would have a set of principles about what the limits of cross-examination are. He would enforce them. In the committee, that is not so easy, because it's in a way also a political process. The politicians, the MPs get involved, and so it's actually very difficult to do so. If he does draw a line, of course, it's going to be also, the committee might be threatened with legal action, and that might delay matters. So what has happened is really the worst of both worlds. We get all the bad things about cross-examination and adversarial system, but we don't get necessarily many of its benefits, because the chairperson, I don't think he was that bad, but he's not a judge, and he doesn't have really the kind of settled principles or rules that a judge would be able to rely on to make sure that in a fair and in a reasonable manner he ensures that the process is fair and that it is actually doing what it's supposed to do, namely to try and find out what the facts are, what actually happened.
Yeah, to that point, and let's elaborate, because you mentioned a little bit earlier on that the work is to establish what is true and what is not true. From a layperson who doesn't know the law, some of the things that came up, you would be forgiven for exacerbating and think, oh, wow, okay, oh, I didn't know this, or oh, I didn't know this. And I guess it's up to you to then do your homework, right? But then in determining what is true or not, like you mentioned, now there's legal representatives that are involved in this. What then, or what happens now with the committee itself? One assumes they will also be relying on legal experts?
Well, I hope they rely on legal experts. Of course, assessment must be made, sometimes both with legal principles. There is some room for disagreement. Sometimes the facts could be interpreted in different ways. My personal view is that given the fact that the Constitutional Court and various high courts have already really answered the question that the committee asked, it's not a very difficult task they are facing with, and that the committee itself has made it more difficult and more complicated than it needed to be, because the task of finding whether the person might be impeached because they happen that they are dishonest or incompetent or whatever, that has been answered many times over by various courts. And unless there is an absolutely compelling reason to question what the court said, I can't see the committee coming to any other conclusion than that itself.
So you don't perceive that Thuli Madonsela's testimony aided in any way after the proceedings? Atim Tongana, speaking to the suspended public protector, she expressed some happiness that at least it was revealed that she did not sign that CX report, the former public protector, that is.
Yeah, I don't think that is going to make any difference, because that is not the basis on which the various courts have made really scathing findings of incompetence and dishonesty, which is not the same thing of making findings that somebody got something wrong or the law wrong. These are really scathing findings. I can't see that it's going to influence that. Maybe I'm wrong, but yeah, it might be politically helpful, but I'm not sure in terms of what the facts really are and what the law says. It might make a huge difference. When you say politically helpful, what do you mean? Well, this process is happening in two spheres. It is a factual a process to find the facts and to establish whether there was a breach. But it's also political, because ultimately, if the committee finds that the public protector is impeachable, it goes to the National Assembly, and there each member of parliament votes whether to impeach or not, and they can do so based on their personal or political convictions, regardless of whether the public protector was found by the committee to have been dishonest and incompetent. So there's another audience, the audience of the 400 MPs, and then of course also the audience, the voters, who will look at each political party's position and might either be persuaded to vote for them or not based on this position, and the party will be bolstered depending on how the ordinary public view these kind of proceedings and who they think is in the right or the wrong. Yeah, and then you've got the acting public protector, Koleka Kaleka, making it known that she fears that the coffers of the public protector are running dry as a result of these proceedings. What do you make of that, if anything? I don't really know what the ins and outs of that is. Obviously, nobody is entitled, who is not paying for themselves, to unlimited funds to run any legal process. There is no such right in our law. To what extent the acting public protector accurately her claims that there is no money is accurate, whether the expectations of the suspended public protector and the legal representatives are reasonable or not, I don't really know. It's not really my area of expertise. Fair enough, and thank you for the indulgence. Pierre de Vos is a legal expert. Thank you.